Thank you, everybody, and it's good to be here before you again. I think I'm going to turn that off because I got this guy on. Normally, when I speak to IRELA, it's to talk about the upcoming reassessment or what you can do to save your clients some money on a tax appeal or tax incentives or legislative changes. But today, what I'm going to talk to you about mostly is what's been going on, recent prosecutions by the IDFPR against attorneys. And it's really kind of a head scratcher to me, at least. I don't know if you know, first of all, who the IDFPR, you probably do, but they're a department of the state. They license and regulate various professionals, including real estate brokers and appraisers. I think they also regulate title insurance agents, if I'm not mistaken.
Yes.
So all of you in the room may in one way, shape, or form be licensed by them. So I think you ought to pay attention to what they've been doing. Last April, we real estate tax lawyers, we have a committee of the ISBA called SALT, State and Local Taxation, and we became aware of a prosecution of an attorney, Nader, who had filed tax appeals on behalf of a client and then received in the mail notice that he was being prosecuted by the department. And I guess when that first came up, we all looked at it and said, well, at least I did. You know, I'm a glass is half full kind of person. And I thought, well, you know, maybe this is a mistake. Because how could whatever he's doing in this situation be considered illegal and that he's preparing appraisal without a license? And then about 2 weeks later, we became aware of another one. And it's kind of like, reminded me when I was watching the 911, you know, when the planes went into the World Trade Center, when the first one hit, all the announcers were saying, well, it's a private plane, it's an accident, and then the second one hit, we all knew it wasn't. And that's kind of what happened here to us. And when that second prosecution happened, we knew that something was going on that was purposeful, it was intentional, it wasn't just an accident. And then we began to dig deeper. And as we dug deeper, and particularly, I don't know if any of you know Nora Doherty Devine, she's a colleague, she does the kind of work that I do. She began, and she FOIA'd from the department she picked out 50 prosecution cases where she wanted to see the files. She wanted to know what they're up to. And they didn't, I don't think, like that so much because they responded by calling her boss and saying, hey, do you know what your associate is doing? And he didn't, actually, and he wasn't too pleased. But in any event, they got the paperwork, and she began to look at these and see what the department was up to, and she began to interview some of the people who had been prosecuted. And I won't get into all what she found, and she found a pattern, and she found it personally disturbing, and she's done a presentation on this, and she may be doing more. But the one case she came up with was the case of Peter Curielli. And I think that all of you may want to pay attention to this one because I don't know if you know Peter, but he does what you do, right? He does real estate closings. And he's been on a 3 or 4 year journey in his prosecution with the IAF, with the department, and it hasn't been too pleasant for him. But let's talk about his case first. Peter was involved in a residential real estate closing, and he was the buyer's broker. He's an attorney, and he's also a licensed real estate broker. His law partner, John Curielli, was the attorney for the buyer, and according to the court papers I've read, John represented the buyers over a long period of time, multiple transactions. They knew him as the lawyer, and he represented them clearly in this case. And Peter handled the brokerage end of things. It was a short sale, and it was contentious. And you know, one thing I've learned over the years is that it's these contentious cases that snap up and bite you. So, you know, practice tip number 1. Try to keep your cool, really, because it's those situations where you let the client get to you or you let the other side get to you is where they tend to force you to end up in trouble. And so after, I guess there was a disagreement about the amount of the broker's commission, and that was contentious. They resolved it, but then when the case was over, both the seller's broker and the seller's attorney referred Peter to the department, arguing that he had violated a particular law. So the department set out and filed a prosecution action against him in 2013. And one of the things that Nora found by looking at these complaints that were brought against people is that the complaints are very basic. They don't tell you very much. You know, they basically say, or many of them say, and in this case, you broke the law. In this case, they said you were both an attorney and a broker in the same transaction. Well, that left Peter Curielli scratching his head because he didn't understand how that was. He didn't view it that way. And so he reached out to them and he asked them, what specifically did I do wrong? And they apparently, my understanding of reading the court papers that came down, refused to tell him and said, you're an attorney, go figure it out. That's particularly distressing, right? That's those two little words we learned a long time ago called due process, right? Pretty basic stuff. But according to the decision of the Lake County Circuit Court, they wouldn't tell him, and they said that violated due process. But it's a long story, we'll get there. So in November, they had some settlement conversations, Curielli and representatives of the department, and I guess they had reached some sort of deal, tentative deal, that if he pled guilty, that they would keep it out of the record and he would have to take continuing education and go on his merry way. Somehow that deal didn't happen. I don't know whether he rejected it or they rejected it. I sort of get the sense that whoever he discussed it with, higher up, might have rejected it, but that deal didn't happen. So after that happened, he then went to the Circuit Court of Cook County and filed a declaratory judgment action, and he asked for a temporary restraining order to stop the prosecution from happening. And my reading of the facts is I think he was representing himself pro se. He probably didn't want to go out and spend the $25,000 or $30,000 or $50,000 it took to mount a really aggressive defense here. And he took the tack that he would challenge the particular statute as being facially flawed, violating the Constitution, and that's a really tough road to hoe. There was another argument he could have made, which was to say that it was flawed as applied to him. He probably would have won that, but he didn't take that tack, and to make a long story short, he lost that appeal, or he lost that case, and that went up to on appeal. That's his first appeal. The decision of the Circuit Court was affirmed, and the case that the department brought the prosecution proceeded. July of 15, there was a hearing. August 15th, his appeal of the dismissal of his declaratory judgment action came out, and the decision of the court, the Circuit Court of Cook County, was affirmed. And then in November, the department rendered their decision after holding the hearing. They fined him $9,500, and they gave him an indefinite suspension of his brokerage license, indefinite, but not less than, then they amended it later and said, but not less than a year. When you look and see what he did, to me, sounds like awfully harsh punishment for what he allegedly did. In February then, he had the opportunity to file into the Circuit Court of Lake County because he was a Lake County resident and ask them to review the decision of the administrative agency. And he filed that appeal. And in September, the Lake County Circuit Court issued their decision, and he won right on across the board. You know, I'm sure he was feeling really good until 30 days later, the department decided to appeal it, the second appeal. So this man has been on a 4-year, soon to be a 5 or 6 year journey in this case. A pretty harsh situation for him. So what did he do that was so wrong? Well, in the Illinois Brokerage Act, there's a provision that says that a broker cannot also act as the attorney in the same transaction. And I bolded and underlined and italicized the word "the," because that is a key word in this whole situation. he was, the question was, he was an attorney involved in this transaction and also a broker, but the buyers had their own attorney. He argued that attorney was the attorney for the parties, and he only, at most, was an attorney. So specifically, what did he do? Now, he was never exactly told what he did, but the Lake County Circuit Court, in their decision, said that basically there were 3 emails, the allegations that he wrote 3 emails to the seller's attorney and the seller's broker. In one of them, he took issues with the figures in the HUD-1. He didn't prepare the HUD-1. He just took issue with some of the, I think, tax prorations. Secondly, he told them where to mail the check for the attorney's fees. The allegation was that was the practice of law, right? And then he made some assertions about what the contract requirements were, what they were obligated to do. And they said that was interpreting the contract, and that was the practice of law. Somewhere I read in the court's order something about a snowblower, right? So how did the department act in this case? Well, did they look out and were they fairly enforcing the law? Did they really see a burning legal violation here that was going to harm the public? Or were they just acting hostile to this particular attorney? I'll let you, I'm not here to bash the department. But, to me, I look at this and I ask myself that question. Did they have an agenda? With 3 attorney prosecutions like this, is there some hostility towards attorneys? Or are they trying to keep us firmly in our lane and out of other lanes? Is that what this is about? I'm not sure. They certainly failed to provide due process. They didn't tell him what he did wrong when he asked. And the Lake County Court, in their order, said so much, specifically said that. They had their witnesses lined up. So they went to trial. He didn't know specifically what he did wrong, so he's shadowboxing, but they knew how they were going to try the case. So they had their fact witnesses. They had the seller's attorney and broker to authenticate these emails and present them and get them into evidence. And then they had an expert witness who used to work for the ARDC, who came in and said that what he did was the practice of law. The court said that nobody can tell the court that no expert witness can testify as to what the law is. That's purely within the purview of the court. So the expert witness's testimony was rendered inadmissible. So, you've got this case proceeding. You show up. You don't know what you're up against. You have somebody seeking to enforce the law, bringing in an expert witness, testifying in front of the trier of fact, who later is deemed, their testimony is kicked out 100%. And now at the end of the day, after the department has lost, this case is now up on another appeal. So they just don't want to let it go. So, I'd suggest to you, a lot of you may, I also have a broker's license, right? I'm an attorney. I think you got to really tread lightly in these circumstances, because this department is looking at infractions in their mind and elevating them pretty significantly. And you have to ask yourself, well, where's the prosecutorial discretion here, right? I mean, many of us will pull out of here today and do a lane change without putting on our turn signal, and that's a violation of the law. But I don't expect that somebody's going to pull me over, throw me up against the hood of the car, put handcuffs on me, and drag me down to the station. If I'm driving otherwise responsibly, most police officers are going to look past that, right? Is that what's going on here or not? You have to ask yourself that question. But I tell you, you think about those things that we as brokers are required to do when we make an offer. We have to disclose that we're a licensed broker. Thinking about it, you have to think long and hard, make sure you're following all those rules. In the Lake County Circuit Court rendered its decision, and they said that he was denied due process, and that his case should, in the Circuit Court of Cook County, should not have been dismissed. They reversed the department's decision and rescinded the sanctions. They said that the things that he allegedly did were not the practice of law. And they said that that the Supreme Court is the one in Illinois solely given the responsibility and authority to determine what is and what is not the practice of law. And Curielli could have probably challenged in his first litigation not the statute on its face, which was a hard road to hoe, but he could have said it's unenforceable as it relates to me because you, the department, have to decide whether these emails constituted the practice of law or not, and you don't have authority to do that. He didn't take that tack. Had he taken that tack, we might have seen a different outcome here. But the court said those emails did not constitute the practice of law. I won't get into all the details as to why, but they said it was not. But then they went on to say, well, but even if those things were the practice of law, he didn't violate the statute. As the statute said, you can't be a broker and the attorney. They said that the buyer had an attorney, the other Curielli. And that person had authority and responsibility to represent them. And the purpose of this statute is to ensure that there's no conflict of interest, because a broker gets paid when the deal closes and they get a commission. So brokers may be motivated to see the deal close. And attorneys are supposed to zealously enforce their clients' rights, and they get paid whether the deal closes or not. So they said here, you know, it was clear that the other Curielli was the attorney and was looking after their interest. He was not the attorney, and they get into a big discussion about what the word the, or I guess it's called, I was not an English major, I guess it's an article, and what the article the means versus the article a or an. And there's a lot of case law in Illinois, believe it or not, that talks about that. And it was very clear to the court that this statute says you've got to be the attorney and a broker to violate the statute, and he was clearly not. So I don't know what this appeal is going to be about, but stay tuned. His journey continues. As to the cases that are near and dear to my heart, it's the tax appeal cases. And so in these cases, the Nader case, Nader had filed a tax appeal to the PTAB. It's Property Tax Appeal Board. It's a place we go to appeal taxes. And he did it on behalf of a friend of his, and the friend happened to be a lawyer, and he contested the assessment of the friend's home. So no good deed goes unpunished, right? And you know, he filed a typical appeal that we tax appeal lawyers file every single day and have been doing for years and years and years and years. He argued that the assessment was not uniform, and he looked at comparable homes and gave them information on the comparable homes. He said that the market value of the house as proposed by the assessor was overstated, and he went to the MLS and he gave them sale comps. His brief is out there for us all to view, and I got to give him a pitch. He did excellent work. He was really thorough. He filled out the PTAB complaint form, which is the first thing you have to do. And like any other government form, you fill in blanks, you follow instructions on the form, and then you submit whatever else you want to submit. And one of the things the forms tell you is an appraisal is not required. So he didn't submit an appraisal. The form says you have to submit at least 3 sales comparables. He submitted 7. And he got the information out of publicly available sources. And he submitted a legal brief. And he titled it legal brief. And in his legal brief, to me, the legal brief is like the closing argument. You submit the evidence, the sales comps, and in the legal brief, you talk about the evidence you submitted, and you argue your case for your client. He discussed the sales comparables and the differences between them. He identified himself as the attorney. It was clear he was the attorney. And he sent this all down to the PTAB on his letterhead. It's clear he was the attorney. He was turned in by the local assessor. The particular assessor out in McHenry County is known to be litigious. He stirs up a lot of litigation, and he was upset about this situation because he considered what this attorney did to be equivalent of an appraisal. The attorney didn't title it an appraisal. It didn't look like an appraisal. It didn't use the word opinion. At least I read it. I didn't see the word opinion. But under the theory, if it walks like a duck and it talks like a duck, it's a duck. This assessor called it an appraisal, filed an appeal to the department, and the department is prosecuting this attorney for that. The next case that came up a couple weeks later involved an attorney named Bass, and it was a similar but different fact pattern. It didn't involve a house, it involved the commercial property. It didn't go to PTAB, it went to the county Board of Review, and he submitted an income and expense analysis. Oh, and by the way, it wasn't contentious. He had made a deal with the assessor, but the deal hadn't been finalized and inked, so there was a filing deadline coming up, and wanting to be thorough, doing his job, he filed an appeal just to make sure, in case the deal fell apart, that he would make sure he had an appeal on file for his client. And somebody turned him in at some point in time. We think we know who it is. I don't want to say because it'll probably come back to finger the person, but somebody had an axe to grind and turned him in. But I think this one here, he makes an income argument, and appraisers make income arguments. And so he submits leases and rent rolls and tax returns, and then argues on the basis of those documents that the property is overvalued. And I think to the department's way of thinking, that looks too much like an appraisal, an income approach used in an appraisal. So the State and Local Taxation Committee, seeing this, became concerned about it. We didn't know at that time about IRELA. We hadn't dug that deep, but we thought this was an issue for sure for real estate tax lawyers and their clients, because if the department prevails on this, lawyers, you're going to have a hard time finding a lawyer to handle very many tax appeals, because most of what we do, the department would say, violates the law. So we reached out to the, and then there was a concern, or even greater concern, that it expands to other areas, because we're not the only ones doing these things. All the people on the other end of the transaction at the county are doing the same thing we're doing. So we file an appeal to PTAB, we submit our evidence. The County Board of Review, they submit their evidence. It's the same kind of evidence we submit. They're doing what we're doing. So if it's the unauthorized practice of appraisal for us, it's the unauthorized practice of appraisal to them, if you ask me. The state's attorneys, when we go to court, they're doing the same thing we're doing. The PTAB hearing officers, when they write their opinions, they've got to determine what the property's worth. And so I think arguably in the same boat. Estate planners, I know there's a lot of estate planners here. How often do you have to consider what something's worth? We'll get to what the standard is that the department says we've all violated, but this question of what property is worth is handled by more than just tax appeal lawyers, estate planners, divorce lawyers, you know, tax accountants, Joe, right? There's a lot of people who could be in the same boat. So we reached out to the ISBA and to the CBA, and the ISBA got involved in a meaningful way because they understood the larger repercussions of this. So they filed in July a declaratory judgment action saying basically that the department doesn't have authority to do this and asking that they be enjoined from further prosecutions. In fact, the department has said they're not going to file any further prosecutions until this is resolved, and they're not furthering these, they're putting these cases on hold until this court case gets resolved. So here's the department's position. They're saying that Nader and Bass basically wrote appraisals, and that they didn't have licenses to do so, and so they violated the law. Nader, they said his brief, they referred to the brief, contained an analysis of comparable sales and an opinion of value. And for Bass, that he used this income approach and came up with an opinion of value. Again, I disagree with what they're saying. I did not see the words opinion of value. They certainly submitted this evidence, and maybe you could argue that what they did constituted the equivalent of an appraisal, but I don't agree with their points. The consequences here are significant. Civil penalty not to exceed $25,000 per occurrence. First offense is a misdemeanor. Subsequent offenses are class 4 felony. I don't know what a class 4 felony is, but I know I don't want to be charged or convicted of a class 4 felony. That much I'm sure. The department looks at the Appraisal Act because there is an Appraisal Act that provides for all this stuff. And there is a definition of an appraiser. It's very broad, as one who performs a real estate appraisal. That's not too helpful. But they define an appraisal as the act or process. I mean, think about those words, the act or process of developing an opinion of value. And so you're putting that together, an appraiser is a person who develops an opinion of value of real estate, you know, going through an act or process of doing that. Now, there are certain exclusions. There's an exclusion for a property owner who values their own property, and I think the words are for their sole use. And, you know, I'm not sure what that means. I guess if I sit down and want to know what my house is worth and go to Zillow, it's okay. But if I take that information and I go submit it to the county and try to persuade them with that information, is that my sole use? You know? I don't think that's so clear. And certainly estate planners and lots of other people go through this act or process. So they paint with a very broad brush, and they say that anybody who does this has violated the law and should suffer these fines. Again, if you move out of your lane without the turn signal and you're not speeding and you're not driving recklessly and you're not harming anybody, you should be fined to the maximum according to this line of thinking. Well, the ISBA comes in here and says, well, hold on a second. Read the Appraisal Act a little bit more thoroughly, and it requires the department to incorporate the rules of USPAP. And what USPAP is the Uniform Standards of Appraisal Practice. Think of it like the rules of professional conduct for appraisers, right? It's the ethical do's and don'ts of what you can and can't do. And in USPAP, an appraiser is defined, and the USPAP, you know, the statute was drafted by our legislature. USPAP is drafted by appraisers, just like the rules of professional conduct are drafted by attorneys in the courts, right? So this is more of a peer concept. And so what USPAP says is an appraiser is one who develops an opinion of value of real estate, and I've italicized and bolded, in an independent, impartial, and objective way, right? And that's kind of important. And why would they say that? And I think they would say that because we rely on appraisals, right? When banks lend, they rely on appraisals. When people buy real estate, they may rely on appraisal. So it needs to be done independently, impartially, and objective in order for it to be a valid appraisal. That's what USPAP says. The ISBA looks at the rules of professional conduct and says, well, what are the rules that guide lawyers? Well, they look right at the preamble, and it says that we're advocates. We zealously assert clients' positions under the rules. We don't violate them, but we can push them to the max. And we're supposed to go to the boundaries of the law. We're supposed to zealously protect and pursue within the bounds of the law. So what the ISBA said is, well, first of all, these attorneys didn't perform appraisals. They acted as advocates. And so that's really kind of the fundamental issue here. You'll see in the next slide is this advocacy or is this appraisal? That the department has no authority to discipline, sanction, or interfere with attorneys while representing their clients. So this is coming down to the Bass thing. You know, the department is trying to tell the Curicelli thing. They're trying to tell Curicelli that what he did in writing those emails was the practice of law. But they don't have authority, we argued, to determine what is and isn't the practice of law. That's up to the Supreme Court. The question in the appraisal thing is when we go in on a tax appeal case, you know, we have the department telling us what we can and can't do. They're trying to tie our hands behind our back and, you know, gag us, give us a little bit of room to say a few words here and there, but we're saying, hey, wait a minute, you're telling us how to do our job. we're advocates, we're advocating, and we can't do it that way. That's the real question here. And so, you know, when I look at it, and now this is my work product, not anybody else's, and I compare it, you know, and I look at these definitions, and I see that, you know, the department says that appraisers give opinions, right? And I'll add that we rely on. You know, the people rely on their opinions as if they're fact. And we have to rely, and they have to be impartial and objective. The ISBA says, well, lawyers aren't that way. We're advocates. We argue and persuade within the bounds of the law, and we try to persuade you to make decisions, and we don't ask you to rely on our opinions. And I'd ask you, you know, when a lawyer walks in a courtroom, what are some of the words we use to describe them? Hired gun? Mouthpiece? You know, it's these kind of words. We're not sworn in as witnesses, even in our tax appeal cases. In fact, the Property Tax Appeal Board has a rule prohibiting us from being both an advocate and a witness at the same time. I don't think people take what we say as fact. I think people understand that we argue for our clients and we try to persuade them. And that's fundamentally what it comes down to. So, you know, the courts are going to have to determine who's right here. And it really comes down to fundamentally what we can and can't do, and we have some agency telling us what we can and can't do, and that's a real problem. The ISBA case is pending. Bass and Nader are on hold pending the outcome, and no new actions presently. The motion to dismiss has been filed. They're saying that you need to exhaust administrative remedies first. And I think they're pointing to the Curacelli case as one of the reasons why. And it's just one of these things where the ISBA is saying you can't do this, and the department saying, yeah, we can, and it's going to have to be resolved by the courts. There are some exclusions under the Real Estate Act. Brokers doing CMAs or broker price opinions are excluded. You don't need to, brokers can do those things without being an appraiser. Specifically, specific exclusion. Assessors can value real estate when doing their job under the property tax code, but only the assessor, not the boards of review, not the Property Tax Appeal Board, not the court, not the state's attorneys. And then we said people or entities who appraise properties owned by them for their sole use are excluded. But I did this seminar for ICL, and there was somebody from the department in the audience, or actually 4 people from the department in the audience, and they said, well, no, taxpayers can file their own appeals. And I said, well, you know, you guys really interpret things how you like to interpret it, because I don't necessarily read it that way, and that needs to be determined. But I think there's a little selective enforcement here. You might have read this summer, somebody sued, what's the big internet firm that, Zillow.
Zestimates.
Saying that the Z-estimate or what Zestimate was an appraisal. And somebody at the department was quoted in the newspaper saying, it's not, it's an opinion of value, right? It's not, because there is an exclusion in the Appraisal Act saying that these computer models are excluded, but it doesn't actually say that. It says the procurement of these automated valuation models is an exclusion, so I don't even know what that means. But he went on to say, but on top of it, they're not, nobody relies on them, and there are disclaimers in these Z-estimates that say, don't use this as an appraisal. So to me, it's like there's, applied to attorneys, it's very strict. Applied to Zillow, it's kind of anything goes. Applied to homeowners, it's, well, we'll be real flexible with you. So, you know, what's the standard? Are we strict or are we flexible? This is part of the concern and the frustration, is it appears that as they look at us attorneys, they are holding us chapter and verse, but looking at others, they might be more willing to be more flexible and reasonable in ways that you would expect them to be, right? I won't belabor this, we've said it before, who's at risk? I think a lot of people are at risk. It's not just us tax appeal lawyers. I think it goes beyond. Okay. So, past all that stuff. Now into the kind of few things, and I'm going to move quickly because we probably don't have a ton of time. But as the regular old tax appeal things, I just like to run a few things by you so that, a few practice pointers you can take home with you and remember and focus on. First thing are tax rates. I call them the real estate DNA. And there's a kind of basic rule here that if you're in areas with low property values, like the south suburbs of Chicago, high tax rates. And if you're in places with high property values, like Winnetka, low tax rates, or Chicago even. You can't change your tax rate, and I just want to jump up to something here, and then I'll come back. These are some examples of tax rates, and this is why I think it's important. You'll see here that the smallest tax rate in the whole county is 5.89%, but the highest, and that's correct, 38 point some odd percent. I've got clients in the south suburbs that have that 38%. I got to tell you, it's a killer on their property value. It's a killer on their ability to get refinanced. They wish like heck they never bought that property, or if they did, that they discounted it substantially. So my message to you on tax rates are, they're a big deal and you can't change them. And if you're buying property for yourself, or you're representing a client on a commercial property and you're doing due diligence, focus in on this. It's not hard. Go to the property tax portal. A lot of you have been there. It's a great resource. Look up the PIN. Look at what the tax rate is. You've got one of these huge tax rates, you better be doing some talking about it, because your client will be real happy if you raise this, bring this to their attention. And if you don't, it's going to be upsetting to them. They're going to figure it out someday. Tax rates in Chicago, you probably close a lot of deals in Chicago. It used to be Chicago had the lowest rates in the whole county because we've got a really thriving tax base that brings those rates down. But a couple years ago, they realized, everybody knows we've got unfunded pension obligations. Chicago knew that, and then they focused on the fact they had the lowest tax rate in the county and said, we can bring those up. So over the last few years, they basically have added supplemental levies that are going strictly to reduce their pension obligations. They amount to approximately 15% of what they were levying before they started this. So Chicago tax rates, aside from the fact that they go up every year because of inflation, are up about 15% because they chose to do that. It's over $1.2 billion by the end of this year. It's probably going to go up, I think, one more time, perhaps, and maybe but they've ratcheted it up now over a few years. It's a really big deal. Not such a big problem in the suburbs because we don't have the political clout that Chicago had to go to Springfield to get the authority to do what they did. We have tax caps. Chicago, the city, is not subject to tax caps, nor are most of your local municipalities, but Chicago Public Schools, which is a big chunk of this, are. And when they went to get budgeted, when the budgets got passed and the stopgap budgets got passed, they created these new special funds that were exempt from the tax cap so that they could do this. So not such a problem in the suburbs unless they all get together and get some political clout as a group. An issue in the Chicago, so as you do tax prorations and stuff, understand they're going up because of these supplemental levies. Tax prorations, kind of the flip side of this is, the old 100%, 110% of the most recent ascertainable tax bill, 105% in a non-reassessment year, and 110 or 115 in a reassessment. That's going to work for you sometimes. It's not going to work for you all the time. The big problem you'll have is when you've got a commercial property and somebody like me went in there and the property had vacancy and we got the assessments lowered, cut in half maybe, because we had a vacant building. You prorate based on that artificially low 1-year reduced tax bill, 110% isn't going to cut it. So this is not an exaggeration. It could be that that tax bill would be $150,000 normally. I get it down to $75,000 because of vacancy. You prorate based on 75. You move into your building, it's fully occupied, no more vacancy, your proration short 75,000. So you want to be on the lookout on commercial properties in particular, do a little due diligence, go to the assessor and board's website and look at what happened with the appeals. Look for vacancy reductions, look for big reductions and ask some questions. Senior freeze, you're gonna run across this one all the time. The senior freeze is going to artificially hold down those tax bills as long as the senior is in there. And the minute the property is sold, promise you, the next tax year the assessor is all over it. And the assessment's going back up to market. So when you're buying senior freeze properties, be aware of it, plan for it, do what you want to do. Large reassessments, you know, we've been through the cycles where they go up, and then they went down, and now they're going up again, and they're going up pretty good. So in reassessment years, you know, you could be looking at 20, 25, 30. Some of the big residential properties and the big condo buildings downtown, they were going up 40 and 45% from really artificially low levels, right? But, you know, pay attention to that. And then you've got the impact of rising tax rates. You know, tax rates in Chicago haven't been going up the normal. They went up the normal plus 15%. So you really, on your tax prorations, you're not going to do this on every residential property, I get it, but on commercial properties, you really do need to do your due diligence. If you're not sure, call us. We'll be happy to talk to you. Go to the assessor and board's website, go to the tax portal, look at the treasurer's website. All those places have the information that you need to do your due diligence. You may reprorate or escrow funds, leave that up to you, but just be aware of it. Tax exemptions. Ralph, how much more time should
I can't give you any more than half an hour.
Okay, so
Take your time.
okay. Tax exemptions. So tax exemptions popped up here in Cook County only because the tax climate is so poor. And, you know, we were talking, George and I were talking before, and I said to him, we have client, you know, when I started out in this practice 25 years ago, people would complain about their assessments and they'd say, if the assessor doesn't like my house, or doesn't like, you know, if he thinks it's worth that price, let him buy it. And, you know, you dismiss that. That's just people being frustrated. But we're getting clients more and more and more who are moving to Indiana and moving elsewhere. It's for real. I mean, this is not, you know, hyperbole anymore. This is real life stuff. The exemptions are there to keep you here. And they're here to incentivize you when you're going to build new, substantially renovate and add square footage, or take a building that's been vacant and reoccupy it. And they're very valuable. If you're representing commercial property owners, you need to be aware of this, because really I think if you miss this opportunity for your client, you know, have you committed malpractice? I think your client will think so, because we get those calls every once in a while. Be aware of it. So I want to talk a little bit about, well, that's all I got, an exemption? Okay, well, I'll talk my way through it. Real quickly, they apply for industrial properties every place. The county loves industrial. So if you got somebody buying an industrial building and that building is vacant, and it's been vacant long enough, it could be anywhere from 6 months to 2 years. 2 years is a safe harbor. The incentive is going to benefit you. If you're building a new building, probably not going to happen so much. It will be there for you. If you're going to add square footage, we have people going up and adding cubic footage. That isn't going to help you. But if you're going laterally and you're adding square footage to the building, you can get an exemption. The big thing you need to know is you have to apply for it before you start building or reoccupying. If you wait until you've reoccupied the building, it's too late. And the big key thing I would tell you, because I'm not going to get into the whole exemption, you know, requirements and all, the big thing is if you've got a client buying a property, especially that's vacant, make it a contingency of your contract that you get at least the village's support. Because when you go to the village with a contract that doesn't have that contingency in it, you say, I need this exemption or my client can't buy the property, and they say, well, show me the contract. And they say, well, you've already committed to buy the property. So what do you mean you're not going to buy it if you don't get it? Try to talk your way out of that one. It's hard. But if you say, no, it's a contingency of the contract, now all of a sudden you're on a level playing field and you have an opportunity to negotiate. Some villages are very supportive, some villages are very unsupportive, and some are in the middle. So, pick up the phone and call somebody, call the village, talk to them, talk to a tax appeal lawyer, they'll tell you. Unfortunately, our county can't get out of its own way on this. So in their infinite wisdom in April, they passed new amendments to the incentive ordinances. And they're making it much more difficult. So we're trying to incentivize people to come, we're trying to convince Google to come, and now we're making it more difficult. Well, now that they've passed these laws and they now start to understand what they just did, they're backing off. So stay tuned. It's very fluid, it's very changing. Call somebody and they'll help you through it. But they're worth mentioning because you cut the tax bill by 60% for at least 10 years. It's real money for people. It's really important. It also applies to commercial, but the commercial has to be in areas that are economically disadvantaged. But you'd be surprised that can cover more places than you think. Tax exemptions. In order to kind of give everybody a tranquilizer and make them feel better about the climate here in Illinois, what we do is politically is we hand out some goodies. So they've handed out some goodies, and they're raising the homeowners exemptions. Cook went from 7 to 10. It's 6,000 elsewhere. The senior exemption's gone from 5 to 8. It's 5,000 elsewhere. And the senior freeze maximum income limitation is up from 55 to 65, and it's 55,000 everywhere. I think that's probably effective for 17. So your clients will start to see that. I don't know how that got messed around in order. I already talked about that. So that's what I've got for you. Happy to answer any questions.
I just want to ask you a question about
Yeah, sure.
the whole situation with these Nader and Bass situations. In talking to Craig Allison, who is telling us, yes, we're going to hold this moratorium, we're not going to file any more prosecutions, the comment was that this is kind of driven by Brian Weaver, who heads up the appraisal section. He's an appraiser. And what's the end game? I mean, are they just trying to put us in a situation where even a residential situation is going to require a formal appraisal now, which would kind of price a lot of people out of the game?
I don't know what the end game is. It's hard to figure because if you look at what they claim, especially Bass on that residential appeal,
Yeah.
if you look at what he did, it's really hard to look at that and say he did anything wrong.
Right.
Nader, I don't think he did anything wrong either, but at least there's maybe a little more meat on the bone there. So I don't know. And homeowners, it's first of all, there's an appraisal shortage. I don't know if you know that. And appraisers, homeowners couldn't afford to go pay $300, $400, $500 appeals. I mean, typical tax savings on these residential cases is a few $100s.
Yeah, it wouldn't work.
So homeowners aren't going to appeal. They're not going to buy the appraisals very often. I don't know what the end game is. I don't get it.
Yeah.
That doesn't make sense to me. And I don't see where the public harm is. I don't see where the problem is.
We didn't talk about that very much, but that is the touchstone of that statute, right? There isn't, in the complaint, there's very little time addressing the issue of public harm or harm to the public. I don't see it. Maybe I'm missing something, but where's the harm?
Well, the appraisal statute apparently was originally, I forget what the nomenclature that they used to describe these situations, but originally it only regulated appraisals written in federally funded loan transactions. But then somebody had the foresight to go take that requirement out, so now it applies in all instances. It was after that happened that these prosecutions started coming, because under the law that was in effect before that change, even under the law, this was permitted because these were not federally funded loan transactions. So the point was, to protect the integrity protect the public in loan transaction and the lending institutions, so they got good appraisals. So then they changed the law. Now they give themselves this argument, this ability to go after other people in these other situations. But I don't see where the harm is, because nobody comes in. I don't go into a tax appeal and say, my opinion is that Ralph's house is worth $300,000 and here's all the information. I come in and say, I argue that you're overvaluing his house, and here's some sale comps.
Right.
And I think they're similar, and, we ask you to reduce the assessment accordingly. We're asking you to make a decision,
Sure. Questions, people?
Mike?
Yes.
Mike, the last page you skipped over, I don't think you had any intent to do that, but it had the words divorce lawyer having to do with appraisal, and
Can't
I'm one
imagine
of
why
those.
you noticed that, Angela.
I'm one of those.
Okay.
And I wonder, what would you have said about that?
Well, okay, so let's say you're doing a divorce. You're handling a divorce, and you have to start looking at division of assets. And there's some real estate involved. And you have to decide, what am I going to try to negotiate for my client with respect to these assets? And you're going to trade. Okay, you're going to keep the house, but you're going to get the stocks and bonds. So now you have to determine what the house is worth. And the act or process of determining what the house is worth, according to the department, is an appraisal. So if you believe the department, if you go to the assessor's website and the assessor says the house is worth $400,000, and you go to Zillow and you kind of poke around a little bit, and you go, yeah, that seems reasonable, then according to what they said, you just did an appraisal. If you go out and order an appraisal, then I don't think they would take exception with you, because the appraiser developed the opinion, not you. But short of you going out and buying the appraisal, then you're coming up with some value of that real estate so that you can do your job, they would say, is the act of appraising the property. Yeah.
I do have a question that I recently had a problem with in a divorce in Cook County. Transfer between husband and wife is a taxable event. You familiar with that?
No.
Oh, okay. I think a
There's
lot
been
of
some
lawyers
overreach in
are
some areas.
not, but if in a divorce, husband, for example, quit claims to the wife, you have to pay the P-tax, or is it the MIDEC?
Transfer tax.
Transfer tax.
Okay.
So I recently had a divorce case in which that had to be done. It was so complicated, nobody knew the answer. I called each of the entities that you had listed up there and said, what valuation should I be using? There was no appraisal. What I ultimately did was simply take the valuation that is in P-tax, the assessor's fair market value. I don't even know what that means. Took that as the fair market value, so maybe I'm going to be getting the phone call.
Right, so, did you go, in order to determine, you had to fill out on the form what the fair market value of the property was.
Correct.
Fair market value is a conclusion, because, it could be different things to different people on different days. So in order to reach the conclusion in your mind, you said, well, the best evidence would be an appraisal, but I'm not going to order one of those for this little simple thing. So I'm going to go see what the assessor says it's worth, and I'm going to look at that and say to myself, does that seem reasonable? Yeah. So you then rendered your own opinion to yourself that this is what it's worth. And so that act or process that you went through, according to the department, is equivalent to that was an appraisal.
Yeah,
to
so
them.
you, like Mike and many other tax assessment attorneys, are going to be worried every time the mail comes in now, because
Yes.
you've
Oh,
opened
yeah.
yourself up.
So we've put disclaimers in every document we submit that says, hey,
Good enough for Zillow.
yeah, exactly. If it's good enough for Zillow, but this is the problem.
Ralph, you were asking about the end game. It sounds like the intention really is for the assessor's office to discourage appeals. And so that's
It
the
could be.
that's the format in which they're going to attack people.
Well, one of the things that Nora found when she FOIA'd these 50 prosecutions is that a large percentage of them either came up in tax appeal cases or where the local assessor turned somebody in who did a valuation for a bank or whatever. It wasn't just tax appeals, but there was a lot of turf, let's call it, protection
Protection, yeah.
that was going on here in terms of who was turning in who. And I will tell you, for me personally, I've had tax appeals, the cases that I filed, where I have been personally threatened by assessing officials, and I'm not going to mention names, that if I didn't drop this appeal, I'd be on that screen. okay? I've had assessing officials threaten my appraisers that they were going to turn them in, okay? I've had appraisers who have been turned in, and I fortunately have an appraiser who's been turned in who said, I'm not going to let them intimidate me again, and the trial continued. Even though the client said, I don't want to see your appraiser get in trouble. And so you are seeing this, and so in Cook County, everybody's accustomed to the tax appeals. But you get into the collar counties and downstate counties, they really don't like it, some of them, that we're in there trying to enforce our clients' rights. And so this is some of the pushback that we get, okay? But, Curielli saw it too. So, I mean, if I would have started this presentation and only talked to you about tax appeal lawyers, you might not be real focused. But we're seeing
broader.
it. We're seeing it beyond that. And then it's not just, I'm not a sky is falling kind of guy, right? But, as we're poking our heads into this, we're going, whoa. And I think it's good that we're talking about it, because the more we talk about it and more people start to see how unreasonable this is, and what's the end game? What's the interest to be protected
Yeah,
here
that's
when
concern.
Curielli has these buyers had their own lawyer. And Curielli told them where to send the check for the legal fees?
And that, when I've talked to Craig Allison about this multiple times, and each time he says, "Oh, don't worry about this. We have the right to enforce the statute and protect, the licensing act issues and protect the public. So what you got to do is you got to go down to Springfield and get an exception carved out for real estate tax assessment attorneys."
Right.
I don't see that happening. I don't think that the legislature is inclined to do that sort of thing to help attorneys right now.
Well, yeah, we don't know. I mean, after I did the presentation at the ISBA, at ICL,
Oh, Ickle.
and I had 5 people from the department sitting there listening to everything I was saying,
Yeah.
and interrupted me during the presentation.
Like just while you're talking.
While I was talking.
Just
Yep. And, but afterwards, one of them stuck around and we talked for 45 minutes, and he claimed that, that they're looking for a political solution to this, because within the department, there's different levels. There's I'm told, the prosecution people who are permanent employees that stay even though the governor changes, and then there's the government appointees. And this, to my knowledge, is these prosecutions happen with the people who are there long-term. And so I can tell you there will be a movement to solve this politically. I mean, the Cook County Board of Review member is on the SALT committee, and he brought it to our attention. He said, we're not exempted.
yeah. But
We're
they're
at
kinda
risk just
neutral
like
on
you're at
the-
risk. I'm sorry?
They're kind of neutral on the direction it's going to take, apparently.
Well, because so far nobody's going after them.
Right.
And maybe they feel safe that they won't, but they're not excluded.
Yeah.
Nor are the state's attorneys. So.
The thing that I find concerning, though, and I'm sorry to interrupt you, but when we look at the situation, we have these attorneys that are doing tax assessment work, and it's the appraisal issue, fine, but the IDFPR is also going after attorneys like Curielli in another situation, so it's a broader net, if you will, and I'm worried about the trend. That's why I'm really anxious to see the ISBA successful in shutting down the Nieder and Bass, because I think that'll send a message.
Yeah.
The Illinois Supreme Court is the one that's supposed to define the practice of law,
That's right.
not the IDFPR.
Great.
More questions for Mike? We have at least 10 minutes more if you want your 1 hour of credit, so somebody think of a question.
I understand that the attorneys who do tax appeals are most exposed because you're up in front of the boards and your point is to come up with an opinion about the value. But as a residential real estate attorney, I've actually turned in some appraisers whose appraisals were so poorly done, dropped 25,000 or 30 off the value of a home and didn't even have the right square foot, didn't describe the home properly, used bad comps. It strikes me that in analyzing an existing appraisal and bringing in my own comps and doing my own analysis of it puts me close to that line. Any of us who've challenged a low appraisal, for example. But as residential attorneys, we do this all the time, whether we're arguing with the other attorney about why they're out of their minds, they should be paying more or paying less, whichever side of the fence we're on. Doing short sales, I did an awful lot of them, thank God there are not so many. I would start my value argument the day we got the contract. I would start gathering that data. So I think if they want to be, jerks about it, those three cases taken together make, I think, all of us very nervous.
Well, that's why we're talking about it.
That's why we're
You're-
talking about
You're
it,
exactly
exactly.
right. I mean, you know, either you're going to paint with a broad brush, you know, the appraisal is the act or process of determining what real estate's worth, you know, in which case, probably everybody in this room at one point in time or the other would have done that, right? Or you're going to say, no, 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 these lawyers are acting as advocates, right? They're not actually going out and giving an opinion that somebody relies upon, because that's what the ISBA is saying. They're saying, look, the department's being very selective. They're only looking at one definition. There's more to the picture. Even the Appraisal Act says you have to have these other rules that require impartiality and everything else, and you know, that takes the advocate right out of the picture. So, you know, it's really about reliance, in my opinion, and it's also about the fact that we advocate, and just the nature of what we do in advocating is we don't give opinions. It's not an opinion that we give. It's an argument that we make to persuade you to reach a conclusion that we want you to reach, right? That's different than me saying, you know, John, I think that house is worth my opinion, that house is worth $300,000, and here's my signature and my certification to that effect. That's to me, that's a way different thing. And that's what the courts have to decide. You know, are we working as advocates, or are we giving opinions like they say? And the problem is, you know, we've got somebody who's not a lawyer telling us what we can and can't do as a lawyer. And they don't have authority to do that. This is, you know, what the argument is.
Well, just for argument purposes, your lawyers are advocates, and they're advocating certain facts that they're bringing to the body that's supposed to make this determination. So where do you draw the line between advocating facts or opinions that you yourself have created versus an appraiser that is an independent person who's licensed, who comes in? Where do you draw the line that yours is as good as his?
Or to put it another way, is there some point in time that an attorney acting as an advocate can cross the line and really be giving an appraisal, right?
But you're advocating for something that you yourself created.
Well, when you talk about advocating using facts, I mean, I think I understand, and I think the proper understanding of advocate is someone who advocates for a position or a change or something like that. You don't advocate facts necessarily, you use facts. And in this case, it was all, to my knowledge, publicly available facts that were being used to support the position being advocated.
Well, and I think the other side raises a point that can't be ignored, and that is there some point, is there a situation in which a lawyer who we all agree is acting as an advocate actually crosses the line and goes too far in their work, and it then smells too much like an appraisal? I think that's a question to be determined. And, you know, there's probably some validity to that, but, you know, most of the time, if you read what we write, you know, and we've rewritten all of our briefs to make this abundantly clear, you know, we're saying that, you know, based on the facts we've submitted and based on the rules, practices, and procedures at the Cook County Board of Review, we ask you to lower the assessment to X, consistent with the market value of this. We're not giving an opinion. We're specifically disclaiming that we're giving an opinion. But, you know, there's a way. It's funny, when we go in on tax appeal cases, you know that there's certain expense levels they use. There's certain cap rates they use. There's certain unwritten rules they apply. And most of the time we're saying, look, here's the facts of our property. Apply those rules that you typically apply. This would be the outcome. And so that's what we're, you know, I don't know if I have a better answer for you than that. Yeah.
Well, if you could get an appraisal for $50 instead of $500,
Mm-hmm.
if you order an appraisal and use that instead of what you're doing?
The question is, if you could get an appraisal for $50 instead of $500,
Yeah.
would you order the appraisal and use that?
Sometimes it's not the cost of the appraisal. Sometimes we're making a vacancy argument, and so that's an appraiser would never write an appraisal for a vacancy argument. Sometimes we're arguing uniformity, equal protection. The appraisers don't write those things. So there are many things that we do and people have been doing for years that appraisers they don't put their toes in those waters. Very often, if the dollars are big and things are cost effective, yeah, we're getting appraisals. But a lot of things are too small and not cost effective, or the arguments don't lend themselves to something that an appraiser would even write. So it depends, you know. Yes.
Ivor.
Go ahead.
Because I don't do nearly as many tax assessment appeals as you do, obviously. I've done a few over the past few years, particularly when the market started coming down.
Yeah.
And my conclusion, and I may be getting paranoid as I get older, is the same one I think you alluded to. This is intended to create a chilling effect on going in for tax assessment appeals and PTAB appeals. Because in the average residential appeal, it's not cost effective
Right.
to bring in an appraisal. And the assessors don't like lawyers coming in and challenging them. I think that's where it's at.
I think so, and we have appraisers that appraise in Cook County that will not go to the collar counties because they've been turned in by assessors in the collar counties over the years, and that has created a chilling effect that the pool of available appraisers is reduced. I had an appeal up in Lake County on a big homeowners association. We had appraisals of every single house. Everybody paid for them. The appraiser walked into every single one of them. He was one of my best appraisers, did a great job. The county sees his work product all the time. The assessor turned him in on like 75. And then it was dismissed because he didn't do anything wrong. But this is the chilling effect. This is the threat that some people, and not everybody's, I'm not, accuse everybody, but it definitely happens. Yes?
So, in turning for a minute to self-preservation, do you think that there's some disclaimer cover sheet that could go on there that cites the,
You don't
this is
need a
not an
cover sheet.
appraisal?
I just recommend a disclaimer.
Yeah, exactly.
I have a one paragraph, 2 or 3 sentence disclaimer that I put on every complaint form, every brief, and lots of the other papers that go into the package so that it's belts and suspenders on everything. I'm not giving you an opinion. I'm an advocate, and I'm advocating for my client. Yeah, I'm doing
And
that.
it's crazy that we're talking about this, but I've advocated before that if you're doing this work and you have, say, an appendix that has all your data, that you're attaching to it, you probably want to call it something other than appraisal in big letters,
yeah, I know, yeah.
It's crazy that we have to go to these lengths and discuss this approach, but
Right.
that's probably a good
And
idea.
I'll start every letter with, I am not an appraiser, and this is not an appraisal, but.
Yeah.
Yeah, or
I
put
mean,
it in a footnote. But I mean, I got to do my job too, and I don't want to diminish.
But do you know if there was anything like that within the 2 cases that did come up over the appraisal
No,
argument?
I read the briefs, and there was not.
Okay.
There's a question over here, Valerie. Oh, Craig.
Yeah.
And really quick, and Mike, fantastic job. This is not intended to be a gotcha moment. I used to be a department prosecutor at IDFPR, and I represent Terry Nader and David Bass.
Right.
This is for people to understand how significant this is. Understand the nuance here of the opinion of value kind of idea. This is not, I'm coming up with a number and I'm determining as counsel for my client, I think this is what the value is. If you read the license law for appraising, if you read USPAP and you go through this, the department is keeping it as broad as, if you receive an appraisal performed by someone else and you agree or disagree with that appraiser's value conclusion, you've formed an opinion about value, haven't you?
Yeah.
And so therefore, you're now in their ballpark. That's the seriousness of this. So I know the gentleman was asking, well, what if the appraisal was cheaper? I don't care if you make the appraisal $1. If you as the attorney then decide you disagree with what that appraiser came up with, by the department's standing, you have performed an appraisal at that point, and that's the concern. And this is for folks that do divorce work, estate work. I don't know, if you're counseling a client on a 1031 exchange, have you ever talked to them about what the implications of that might be? You're probably talking about some kind of a impact of value. And it's not actually coming up with a hard and fast number. It's about having an opinion of value, and that might be value up, value down, value same. Doesn't have to be represented in digits.
More questions? I know there's a question over here.
Hi, this is almost exactly on point. I'm seeing something that starting up again that happened 10 to 12 years ago that started to have the real estate market collapse or depress, and that's on appraisals of FHA property. I have one right now where I don't know what to say, because my client agreed to sell for $330 with a $5,000 closing cost credit for the FHA. That seemed reasonable. The lender comes back to me and says, this guy doesn't have enough money for the closing costs, so we want you to increase the sale price another $7,000 and give him a $12,000 closing cost credit. What, I would want to say something like, well, but even if it only appraises at $5,000 over our agreed price, he can't get out of the deal. I mean, how can it appraise out at another $7,000 worth? And what do I say as my opinion to that request?
You're highlighting the problem. It boils down to that if you take literally what these folks say, that anybody who weighs in one way or the other, going through this act or process is treading in these areas. Now, I don't know if you change a contract price and raise it and give a credit. I don't know. That doesn't sound to me like it's terribly problematic. But the whole thing, it just leaves us all confused and concerned. And
But it is problematic because my client agreed to sell it for a certain amount, and when they raised the price by $12,000, and he gives a
Suggest you arranged to have it raised. They're not going to raise it unilaterally.
no, this is after the contract was
Yeah.
signed. I don't see how that. I don't see how I can be involved in that transaction, because that's what happened for the market to collapse. Was all of these appraisers were inflating the value for people that couldn't afford the house in the first place.
Right.
And now it's the loan is more than the value of the house. How do I don't know.
Very.
yeah.
Agree.
I think the difference with what's being described in your case is whether or not somebody's going to ask the appraiser to appraise it at this higher amount. And if the appraiser came back and did, the problem that I had seen with appraisers who I was close with 10 years ago was they were being blacklisted if they didn't change figures that they didn't agree with. It's a different thing, I think, if the appraiser agrees, yeah, there's more value in this house, because a lot of them tend not to be appraising, a lot of them tend to want to keep pretty close to the contract price, regardless of value. They did, but was that before or after the appraisal was my question. Because, so the question was,
The lender asked
Well-
you to change it, I understand.
correct, but if the question is whether the appraisal had undue pressure put on them to agree with a value he didn't think was in it. We've all had sellers tell us they're selling for too little versus too much, but
So now, when I suggested that we have questions, that we have to have the question and answer session. Thank you for responding. But now we got to bring it to an end. Thank you very much. There's a couple of things we need to address. One more question, Jack? Or Mr.
Right here.
Coe?
I was just going to say that I don't think it was the lender that was asking that the price be raised, because under the new laws, that would be illegal. That basically is mortgage fraud. Now, it might be a mortgage broker who is an intermediary that's looking to short the fire to somebody else, but it would never be a lender that tells you to do that, because right off the bat, you can't even represent the client anymore.
So
Well,
we can
there
have
are
this
brokers.
conversation continue after the meeting.
There are brokers that shop fires
I'm
around.
so sorry. We've got to get to the closing here, and we got to do a couple of things. Please continue, off mic. But a couple of things. If you want credit, fill out your evaluation form. I wrote an article on this case and the ramifications. It appeared in the McHenry County Bar Association newsletter last month. I've provided it to the Real Estate Law Section Council. Hopefully, Mr. Whiteman and his wisdom will see to fit to publish it in the newsletter in the near future. We talk about some of the issues here. We talk about the futility of doing what the department says, which is that Nader and Bass should just exhaust their administrative remedies. Talk about an endless whack-a-mole game with every prosecution. We'll post that article on our website, at least in its draft form. And we'll also post Mike's PowerPoint on our website, because I know that on the screen it's been a little bit hard on Facebook Live to read this. By the way, later, if you want to see this and you want to recall what Mike was saying and maybe you missed something, this will be saved on the IRELA Facebook page as Facebook Live video. Finally, Our holiday gathering next month, it'll be on Tuesday the 12th. We'll have a CLE at 4 o'clock with Lawyers Assistant Program. The executive director is going to come in and do a presentation in light of the changes in the MCLE professionalism requirements. She'll be talking about reducing stress and avoiding burnout in the practice of law. I don't know if there will be yoga involved or not, but it'll be a relaxing and enjoyable time. We'll have the holiday gathering in the lobby immediately thereafter. We have a couple of milestones. IRELA turned 20 this year. Back in 1997, John O'Brien founded this organization, so we have a cake back there that says IRELA's birthday. Also, John O'Brien himself turned last month, and there's a different color cake. Now, guess which one is the green cake? For John. Thank you, everybody.